I feel like I just watched John Wick for the first time. That was violent. All right, so it's June 27th, and Reggie's reply has just come out. Jason Seibert just filed it, and I'm going to read it to you right now. And I haven't read it yet, so you're going to catch my first reaction to the read. And I'm pretty excited about this, and yeah, I hope you enjoy. All right, here we go. Document 125, filed June 27th, 2025, United States District Court, Eastern District of New York. Securities and Exchange Commission is the plaintiff against Reggie Middleton, Veritaseum Inc. and Veritaseum LLC. Oral argument requested. Defendants reply to the plaintiff's opposition to FRCP 60D3 motion to vacate order for fraud upon the court. Franklin Jason Seibert, Seibert Law. And this, of course, is Reggie's attorney. June 27th, 2025. All right, introduction. The Securities and Exchange Commission, SEC, replied on June 20th, 2025 with an objection to the defendant's motion to vacate for fraud upon the court. Now comes the defendants with their reply. The SEC would have this court believe that it is perfectly fine to lie to the court during a motion for an asset freeze so long as opposing counsel is there and there is a later settlement. Oh my God. You just torched him. One line. The SEC would have this court believe that it is perfectly fine to lie to the court during a motion for an asset freeze so long as opposing counsel is there and there is a later settlement. Damn. Will this court affirm that the SEC's belief that it is okay to defraud the court, to seize parties' assets, and cripple their ability to defend themselves? On August 12, 2019, the SEC, through their attorneys Tenrero and Suthamanant, moved the court to obtain an asset freeze from Judge Hall. While not a final adjudication of the facts, far from it, the SEC defrauded the court to obtain relief that undoubtedly harmed defendants. It is this very type of abuse that the court considered in Hazel Atlas and its progeny. The SEC states that Sierra should apply. However, Sierra was about fraud on the parties, not fraud upon the court. The entire analysis of the defendant's objections, subsequent settlement, and reliance on Sierra are wholly misplaced and ignore FRCP 60D3 and its intent. Instead, the SEC built a straw man by arguing that FRCP 60D3 should apply. It does not. The entirety of the SEC reasoning fails. To reiterate, the defendants showed that the SEC defrauded the court when it filed documents and sought relief from Judge Hall claiming that funds were dissipating to Mr. Middleton's personal account. The SEC did not deny that it filed documents stating that assets dissipated to Middleton's accounts. Okay, I'm going to go back here. I'm going to finish this paragraph. It does not deny that they knew that the account was a corporate account on the date of the filings, and it does not deny that Mr. Tenrero knew that the account was a corporate account when he argued these things to Judge Hall. I'm going to go back to this footnote right here. The SEC appeared to hold a similar viewpoint in the case of SEC versus digital licensing, resulting in significant sanctions against them. In their reply dated June 20th, 2025, the SEC reiterated the same unsuccessful arguments, indicating a lack of lessons learned from the Utah Federal District Court's $1.8 million sanction against them for fabricating evidence to obtain an asset freeze. This is fire. Oh my God. Look very closely at the justification for the asset freeze as argued on August 12, 2019. Judge Hall asked specifically when the dissipation began, and Mr. Tenrero stated confidently and clearly that it occurred at the same time as it was alleged in the complaint, stated in the memo in support of the TRO. In Mr. Tenrero's declaration in support of, and Mr. Duty's declaration, that the dissipation went to Middleton's personal exchange account, which Mr. Duty identified at Kraken. There is only one Kraken account listed on DE6, and it is listed as being owned by Veritaseum, not Mr. Middleton. Now, the SEC claims in its reply, DE 125, that Mr. Duty corrected the record with his subsequent declaration. However, aside from the fact that Mr. Duty is not a lawyer under obligation of candor, he does not actually correct the mischaracterization. Instead, he says that he understands now that the account belongs to Veritaseum. See DE 43. Paragraph 13, I think that is. This is a temporal statement that begs the question as to what Mr. Duty knew on August 12, 2019, and why Misters Tenrero and Suthamanant withheld that information from him, as it is clear from DE 6 that the attorneys from the SEC knew the truth. Further, as evidence from the record, DE 6 that attorneys for the SEC knew the truth on August 12, 2019. Why did they file knowingly false documents and make knowingly false statements? Stated simply, because the SEC believed that it could lie to the court to obtain an asset freeze and there would be no consequences. Ooh. The court knows that the SEC defrauded this court. This court knows at the time of the filing and argument on August 12, 2019, the Kraken account was claimed to be Mr. Middleton's personal account, was not, and that the SEC, specifically Mr. Tenrero and Mr. Suthamanant, knew that. CDE 6. This court knows that Judge Hall specifically on August 12, 2019, asked when the dissipation started that her goal was to prevent dissipation, specifically stated that she was not going to freeze personal accounts, but only corporate holdings to maintain status quo. See Seibert Declaration, Exhibit 9, page 36. This court knows that only urgency created by the SEC to justify the freeze on August 12, 2019, was their claim of dissipation of funds out of corporate control. Quote, when did the alleged dissipation of assets take place? See Seibert Declaration, Exhibit 9, page 11. The 30th and 31st of July, responded Mr. Tenrero, ID page 11. This court knows that Judge Hall told Mr. Tenrero that she was specifically relying on his statements at the hearing, quote, so I don't have anything to balance their arguments but to accept it as true, end quote, ID page 36. Number 5. The SEC claims in its objections to the present motion that the various unknowns accounts and transfers were justifications for the lack of clarity and mischaracterization in describing the dissipation. However, today's revisionist reasoning does not match the documents filed with the arguments made at the time, that the dissipation was to Mr. Middleton's Kraken account. The SEC did not argue that dissipation was occurring on July 30th and July 31st to various cryptocurrency wallets. It alleged they were dissipating to Middleton's personal exchange account, a known false statement. See DE2, DE5, DE6, and DE7. Also see Seibert Declaration Exhibit 9, Hearing Transcript. Number 6. This court knows that the subsequent duty declaration is not a correction, but instead a half-attempted excuse that states Mr. Duty, quote, understands now, end quote, emphasis added, that the account was corporate. CDE 43. SEC today would have this to be a correction. However, a correction would be, quote, I knew at the time of my first declaration that the Kraken account was a corporate account based on documents that I received. However, I failed to accurately reflect that, end quote. No such recantation or similar statement exists. Whew. Number 7. This court knows that Mr. Duty was under no obligation to correct the record as the duty falls to Mr. Tenrero and Suthamanant. At no point in the record do either attorney, prior to the objections filed by defendants, or even today, acknowledge that the information sworn to and provided was not correct. Further, this court knows that the obligation of candor and correction falls at the time the statement is made, not by a third party, and not after the damage of an asset seizure was completed. The judicial standards applied when attorneys lie to the court. Defendants specifically made this motion, supported by factual evidence in the record, that Mr. Tenreiro and Suthamanant defrauded this court and failed in their duties under ABA 3.3, absent from the SEC's reply in any declaration or affidavit in Mr. Tenreiro's or Mr. Suthamanant's name. King versus First Am, Investigations 28 F3D 91, found that when an attorney failed to submit an affidavit, quote, speaking in his own name, end quote, to deny accusations of fabricating evidence, the district court was permitted to, quote, draw the adverse inference that the facts alleged were true, end quote, 28 F3D at 95-96. It is one thing for a defendant to remain silent in the face of allegations in a complaint, or not to respond to every allegation in a motion for asset seizure, as the Debtbox court correctly points out, but it is a completely different matter, as King states, when an officer of the court faces allegations of fabricating evidence. Not only can this court accept as fact everything the court knows from the record, but it also infer that the allegations that Mr. Tenreiro and Suthamanant lied to the court are true and well. Whew. Defendants meet required standards under FRCP 60D3 and Hazel Atlas and Gleason. Rule 60D3 provides that Rule 60 does not limit the court's power to set aside a judgment for fraud upon the court. So the moving party need not satisfy Rule 60D3 elements or one-year deadline. Hazel Atlas Glasgow versus Hartford Empire Co. Relief available, quote, regardless of the term of the judgment's entry, end quote, generally as cited in Defendants DE 119. The four-part test required to meet fraud upon the court were defined by Gleason versus Jandrucko, 860 F2D 556. As a supplemental inquiry, the Second Circuit turns to Kupferman versus Consolidated Research. Defendants must, we got another footnote here. So defendants must show 1. An officer of the court, 2. Directed at the judicial machinery, 3. Made a knowingly false statement, 4. While under the duty to disclose, and 5. And the court relied upon it when making a ruling. Kupferman versus Consolidated Research, 49 F2D 1072, citing Demjanjuk versus Petrovsky. Sorry, I'm butchering everyone's name here. 10 F3D 6th Circuit 1993, citing Hazel Atlas. All right, let's go back and check out this footnote here. The contents of the complaint ordinarily are nothing more than unproven allegations. This underscores the extraordinary nature of the relief the commissions obtained here and the grave harm suffered when a party abuses the judicial process to obtain that relief. This is cited as SEC versus Digital Licensing, Inc. And this is the Debtbox case. So moving back on here. So addressing number 1. So I believe what they're doing is they're referencing number 1 here. So number 1, an officer of the court, Mr. Tenreiro and Suthamanant, at the time of the filings and the time the statements were made, were officers of the court and made appearances on this docket. Number 2 up here, directed at the judicial machinery. 2. On August 12, 2019, filings and statements were made directly to the court and to Judge Hall, and relief obtained. So 3, made a knowingly false statement. 3, per the reasons stated above, made knowingly false statements. 4, while under duty to disclose, at all times were under ABA and New York State Rule 3.3, duty of candor, among other stated duties, to disclose the false statements, and more correctly, to not make the false statements. And 5, let's just go back up here, and the court relied upon it to making a ruling. And 5, and Judge Hall relied specifically on those false statements when ordering the asset freeze, as evidenced by the transcript of the TRO hearing. Defendants met their burden. Relief sought, vacatur under FRCP 60D3. The SEC's opposition repeatedly treats Rule 60D3 as if it inherits Rule 60D3's one-year cutoffs, as well as fraud upon party provisions, invoking such cases as Sierra and Anderson that dismissed routine discovery misconduct. Hazel Atlas and Universal Oil, however, hold that courts possess an inherent timeless power to vacate judgments tainted by officer of court deceit. The United States, the Supreme Court, has long held that courts possess an equitable, inherent authority to vacate judgments procured upon fraud upon the court. Hazel Atlas set aside a 9-year-old appellate judgment, stressing that, quote, relief will be granted regardless of the term of their entry, end quote. 2 years later, Universal Oil reaffirmed that, quote, there is no time limitation on the power of a federal court to investigate whether a judgment was obtained by fraud, end quote. These cases antedate Rule 60D3, 1-year bar, and were expressly preserved when Rule 60 was amended. Rule 60D3 now codifies that the rule, quote, does not limit, end quote, a court's power to set aside a judgment for fraud on the court, confirming the absence of a limitations period of Rule 60D3 prerequisites. As established in initial filings and this reply, defendants have met the standard for relief under FRCP 60D3, and this court could grant its motion on these pleadings alone. However, as defendants and amici agree, it would be prudent and reasonable for the court to hold an evidentiary hearing to determine the extent of the deception prior to making a final decision. Damn. Confidence. Defendants request vacatur of DE 61, dismissal without prejudice, return of all assets seized in 2019, and attorney fees from 2017 through to present day. Defendants remind the court that its powers are not limited by FRCP 60D3, but only explicitly stated under that rule. The court's powers extend beyond Rule 60 and Rule 11 when the rule or statutes are not sufficient, which allows the court to craft a solution in equity through its inherent powers. See Debtbox. To the extent an evidentiary hearing is ordered, limited discovery from the SEC should be required. 1. Documents from the SEC that shows any subpoenas and responses to subpoena related to the Kraken account ownership. This actually is good because there was a FOIA request initially submitted by CryptoMM that came back with nothing. And then after the bar complaints submitted to the AGC for Jorge Tenreiro or against Jorge Tenreiro, all of a sudden another email came back with 84 pages of subpoenas from the SEC to Kraken. The problem is there was no replies in that batch of emails that were sent from the FOIA department. So we have proof that 84 pages of subpoenas to Kraken, but we don't have the replies. So this is what this is asking for here, and this will prove that the SEC knew at the time that the Kraken account was in fact corporate. 2. Request documents of all accounting and transfer information related to the alleged dissipation. Again, this is Daniela's confirmation that wires meet the invoices. They match up, which disproves the dissipation theory. Subpoena any and all internal emails related to this matter from 2017 to the present date, from within the SEC, from the SEC to outside parties, and or outside parties to the SEC. And this could include emails to the Jamaican Stock Exchange and possibly even the Nigerian Stock Exchange. So the Jamaican Stock Exchange, Reggie had a memorandum of understanding and a joint venture agreement with the Nigerian Stock Exchange. Both of them were destroyed because of the SEC's allegations here. And then order Misters Tenrero and Suthamanant, Mr. Duty and Miss Daniello to appear and provide testimony. Whew. And such other information that court deems necessary. Respectfully submitted, Franklin Jason Seibert. Seibert Law. Oh my God. I feel like I just watched John Wick for the first time. That was violent. I'm kind of looking forward to an evidentiary hearing. I gotta say, this. I want to see Jason just skewer these four. Order Misters Tenrero and Suthamanant, Mr. Duty and Miss Daniela to appear and provide testimony. I want to see that. All right, I'm going to end it here. That was insane. Great job, Jason. Hats off. And to the rest of the community, stay inspired.